Good afternoon. We're going to continue with legal liability. Today we're going to talk about securities law. We're going to take our little case involving Car Sales Inc. and now we're going to modify it for securities law. Securities Act of 1933, Section 11. Securities Exchange Act of 1934, Section 10b-5. Jerry is the general manager of Car Sales Inc., which is a closely held company. It's not publicly owned. Jerry is the general manager and she owns some stock in Car Sales Inc. It's a family-owned business, but several years when they had record profits, the company rewarded Jerry with a bonus, and instead of cash, they gave her common stock in the company. Jerry needs some money, so she writes a letter to her friend Mary. We all remember Mary, who lives in New York. And she asks her friend Mary if Mary would like to buy some common stock in Car Sales Inc. She wants to sell her stock, Common Sales Inc. stock, to Mary. Jerry also mails a copy of the audited financial statements for Car Sales Inc., which have been audited by Miller LLP. Mary decides to buy some stock from Jerry. Car Sales Inc. suffers a large loss and is going bankrupt. We're talking about the Securities Act of 1933. Mary's attorney believes she can show that the auditor was negligent. Is Mary likely to prevail if she sues under the Securities Act of 1933? And the answer is no. The Securities Act of 1933 applies to initial public offerings where the company sells the stock. It covers any person and only the person acquiring the security. The plaintiff is not required to show reliance on the financial statements, and the auditor is liable for ordinary negligence. But this was not an initial public offering. Mary bought the stock from Jerry, a person, not from the company. Section 11 says that any part of the registration statement, that's where you're registering the stock to be sold, contained an untrue statement or material fact. So auditors are liable for ordinary negligence under the Securities Act of 1933 for initial public offerings, the registration statement for the initial public offering. So if it were an initial public offering, then auditors are liable for ordinary negligence. But in this case, it was not. The Securities Exchange Act of 1934, on the other hand, regulates transactions on secondary markets, transactions where investors, third-party investors, are exchanging the stock. In an initial public offering, the company sells the stock. In an initial public offering, the company produces the financial statements. So the Securities Act of 1933 only protects the interest of those acquiring the security. The one selling the security is the company, which is the producer of the financial statements. If the financial statements contain errors, it is the company's fault. Securities Exchange Act of 1934. Again, we've got Jerry, general manager, Car Sales Inc., private company. Jerry owns some stock. She received it over the years as bonuses. Jerry needs some money. She writes her friend Mary in New York. Jerry also mails a copy of Car Sales Inc.'s audited financial statements to Mary. Mary buys some stock from Jerry. Car Sales Inc. suffers a loss and is going bankrupt. Mary's attorney says she can show the auditor was negligent. Is Mary likely to prevail? Now, it's important that you remember that Jerry mailed the audited financial statements to Mary. And the reason that's important because even though it's a private company, and even though the company's not required to file with the Securities Exchange Commission, the Securities Exchange Act of 1934 covers certain companies. It also covers certain types of transactions. So if the transaction involves interstate commerce or the mails or any facility of a national security exchange, to employ any device, scheme, or artifice to defraud, to make an untrue statement of material fact, to engage in any practice or course of business which operates as a fraud or deceit. So this is often called the fraud statute. So even though Car Sales Inc. Is not a public company, transactions may be covered by the Securities Exchange Act of 1934 if they use interstate commerce or the mails to perpetrate a fraud. Please don't ask me what if it's an email. I don't know. Okay. What's the standard care under Securities Exchange Act of 1934? Will Mary likely prevail if she can prove the auditor was negligent? The answer is no, because the Securities Exchange Act does not hold auditors liable for ordinary negligence. The Hochfelder case in the book talks about, and Judge Powell, this was the Supreme Court. I shouldn't say Judge Powell, Justice Powell. This was the Supreme Court, the United States Supreme Court. When a statute speaks so specifically in terms of manipulation and deception, of implementing devices and contrivances, these are the commonly understood terminology of intentional wrongdoing. When the history of the law reflects no more expansive intent, we, the court, are quite unwilling to extend the scope of the statute to negligent conduct. So the Supreme Court ruled, wait a minute, the law's pretty specific here. It's pretty obvious it was written to prevent fraudulent conduct, and we're not going to hold auditors liable for negligent conduct. Remember, the law said to employ any device, scheme, or artifice to defraud, to engage in any practice or course of business which operates as a fraud. And this was what the court was referring to and saying, wait a minute, we're not going to hold auditors liable for negligence when the law itself is so clear it's concerned about fraud. Securities Exchange Act of 1934, transactions on secondary markets, and as any person acquiring or selling the security. Now, they must show reliance. They must show that they actually relied on the financial statements and the audit opinion. Hochfelder showed, as we just talked, auditors are not liable for ordinary negligence. Now, we know auditors are not liable for ordinary negligence, and we know they would be liable for fraud. I believe there's subsequent cases where auditors have been found liable for gross negligence or recklessness. So we're going to assume that the auditor would be found liable if they're grossly negligent or reckless. But we know they won't be. The Supreme Court says, no, they're not liable for ordinary negligence under the Securities Exchange Act. It's a little different. It holds auditors. Securities Exchange Act of 1934 covers both the buyer and the seller in secondary markets. And I think it makes sense. Who sells the stock? Well, it's a third-party investor. Who produces the financial statements? the company? Is it possible for the seller to also be harmed? Could the company understate their revenue? There have been cases where companies understated their performance because management was going to do a buyout. So management understated the performance of the company in order to make it cheaper to buy back the stock. In that case, the seller's interests were harmed. So on secondary markets, the Securities Exchange Act protects both buyers and sellers. There's a little table, make sure it makes sense to you. Do we agree? I guess it doesn't make any difference whether we agree or not. Auditors will be held liable for gross negligence, recklessness, constructive fraud, or fraud to third-party investors. That's true in both the common law and in statute law. Notice the federal securities laws do not offer recourse to third-party investors for ordinary negligence in the secondary markets. The book talks about managing legal liability. Make sure you understand the client's business. Document your work, document your work, document your work. Your work papers need to be very clear. Be skeptical. The definition of professional skepticism is fair game on any test. Thank you. There's one more section to this chapter where we'll pull together some odds and ends.